chose to do forensic pathology. So that completed my 5 years, and then I did another year of forensic pathology. And then over those 5 years, I took my board's examination in general pathology, anatomic clinical pathology, and then completed my extra year in forensic pathology, and then I took my boards in forensic pathology.
Okay. And what's the difference between the forensic pathology and the general anatomical or clinical pathology?
Anatomic and clinical pathology are just the basics of, again, the studies of tissues and structures of the body for the anatomic part, and then the study of the pathologic changes in bodily fluids for the clinical pathology part. Whereas forensic pathology is a subspecialty of pathology in general, where we go on to train in understanding not only what the disease processes are that may cause someone's death, but also whether the injury that they sustained was enough to cause their death as well. So it's being able to understand the lethality or the ability of disease to cause death versus injury to cause death.
And during that residency period, is that a classroom component, or is it practical, or is it both?
Both.
Okay. And so what kinds of things do pathologists do, or you do yourself when you're in a residency, and how does that carry through to what you do today?
We spend our time on various services alongside our what we call attending pathologists. So those are our supervisors that are in charge of our training and practical experience. So we get instruction through lectures, and we also work on services such as, for instance, surgical pathology, where when someone goes into surgery, they have some tissue taken, then the pathology resident is taught how to prepare those tissues and look at those tissues under the microscope and to look for signs of pathology or disease processes. And there are a number of different services in pathology, such as surgical pathology, or like hematopathology, which deals with the bone marrow and the blood system, and other specific areas of pathology where the pathology resident both learns and also gains practical experience on those services.
And you indicated that at the end of your residency, you took other courses, and then you talked about testing and board certifications. What's a board certification?
Yes, that's after the resident in training has completed a number of years for that particular subspecialty in pathology. Then that person is qualified to sit and take the examination for, in my case, it was anatomic and clinical pathology combined. And then after an additional period of training, I was qualified to sit for my forensic pathology board certification examination.
Okay. And what's the purpose of the board examination in those fields?
As part of the requirement to become board certified, one must again complete the required years of training and then pass the examination in order to go on to practice as what we call an attending or a regular, in my case, forensic pathologist, or in the case of a pathologist that works in the hospital, a anatomic pathologist or a clinical pathologist.
So are you board certified?
Yes.
What's your board certification in?
I have board certification in anatomic, clinical, and forensic pathology.
And how long have you had that board certification?
The anatomic and clinical pathology board certification was in 2001, and then I got my board certification in forensic pathology in 2002.
Okay. And is that board certification a prerequisite to have a license to be a doctor?
No.
Okay. Do you have to have a license to be a physician in the state of Ohio?
Yes.
Okay. And did you receive that?
Yes.
When did you receive that?
That was in 1999.
Okay. And so is there a similar requirement for education, experience, and testing?
Yes, similar, being that one has completed medical school and then taken the examination, a series of examinations, in order to become licensed to practice medicine in the state of Ohio.
Okay. And is your license in good standing?
Yes.
Is your board certification in good standing?
Yes.
Okay. And do you do anything throughout your career to keep those in good standing?
Yes.
And what kinds of things do you do to keep them in good standing?
That would include obtaining the necessary continuing education credit to maintain my license in the state of Ohio. So every 3 years we have to renew our license and show that we've obtained the continuing education credit to do that. And also as far as forensic pathology and my anatomic and clinical pathology training, I took my examination before the point in time that we had to renew. The ones that took their examinations after that period of time, I think it was 2006, those individuals have to renew every 10 years. So they have to sit for an examination and renew every 10 years. But I took it before then. However, I still have to attend annual meetings, such as the National Association of Medical Examiners meeting or the American Academy of Forensic Science meeting, and we obtain credits, educational credits for attending those meetings.
And to date, everything is current. Is that correct?
Yes.
Okay. And so as a forensic pathologist now, do you supervise other students similar to the way you were supervised?
Yes.
Okay. And how long have you done that for?
Since approximately 2007.
Okay. And do you, part of your position, do you do any publications or do research in the area?
Yes.
And what kinds of things do you research and what have you published?
I have 2 book publications, one dealing with water-related death investigation or drownings, and another book publication on death certification. And I have several smaller journal articles on various things, including injury, forensic toxicology, so various areas of forensic pathology.
Okay. And when you say you've published, in what types of publications are those? Where does one find those?
In a couple of forensic pathology journals, one that comes to mind, the American Journal of Forensic Medicine and Pathology journal. And as far as the book publication, that's for the publishing company related to the water death book. And I self-published the death certification book.
Okay. And are those publications, when you publish, are they peer-reviewed?
Yes, the book publication for the water-related death investigation, and then the other several journal article publications that I produced are peer-reviewed.
Can you explain to the jury how Cuyahoga County, your office, would receive cases?
Yeah, and that depends. If the death has taken place inside of Cuyahoga County, so any city inside of Cuyahoga County, then the death is reported to our office, and the information as far as the circumstances surrounding that person's death is reported to us, and we determine whether we accept jurisdiction over that death. And if we do, we go ahead and investigate it further. That's one situation. And then the other situation is we also provide autopsy services for some of the surrounding counties, including this county. So an investigator would report the death from that particular county, and then the decedent or the deceased person would be conveyed to our office for an autopsy.
Okay. Do some counties not have forensic pathologists?
Yes.
And is there a difference between a pathologist and a county coroner?
In the state of Ohio, there can be a difference.
Do you know? Do you know what those differences are?
Generally, so there's 88 counties. 86 of them are served by a coroner. The coroners are elected. In the state of Ohio, the coroner has to be a physician. Doesn't necessarily have to be a forensic pathologist, although there's coroners in Ohio that are forensic pathologists. So that's one difference versus the office that I come from, which is a medical examiner's office. Those individuals are pretty much always physicians, almost always forensic pathologists, and they are appointed by the local body of government, such as the county executive.
Okay. And are you familiar with whether Carroll County has a forensic pathologist?
I don't know that they do have one. I'm aware they have a coroner and would refer and have referred cases to our office for autopsy.
Okay. Did you have the occasion as part of your duties to become involved in a referral from Carroll County involving Matthew Michael Mott?
Yes.
could you tell the members of the jury how your office became involved or how you became involved?
Initially, the death would have been, or was in this case, reported to our office, and the paperwork, which is the order of the autopsy, would have been sent to our office. And following that, the body was sent to our office. So first, someone has to call our office and report the death, and then there's things that happen that will allow the body to be transported to our office.
Okay. And do you recall when you became involved?
Yes.
Okay, and when was that?
I performed the autopsy on May 5th of 2021.
And is there a particular way that when you receive a call, how a forensic pathologist is assigned?
Yes. So on a daily basis, we have a conference where the pathologist will gather and go over all the recently acquired cases or the decedents or deceased individuals. We go over their histories and the circumstances, and then after that period of time, the pathologist will sign up for that case of the day. So it's either they will sign up for the case or they're assigned the case by our supervisor, so one or the other.
Okay. Were you assigned this case or did you sign up for it?
Likely I was assigned this case. At that point, our cases were being assigned, so that our supervisor would assign the cases to us.
So when you get the assignment, or when you got the assignment for Matthew Michael Mott, what's the first thing that you did?
So after the morning conference, then I would go upstairs and begin my initial examination. In certain cases, sometimes the forensic scientist will need to examine the body, particularly if there's any clothing on the person, or say if their hands have paper bags on them. The forensic scientist would be involved initially with the examination of the body, and then following that, depending on the circumstances surrounding that case, there may be an x-ray that's performed, particularly in cases involving anything that might be retained in the body. The pathologist needs to know that, so an x-ray would be performed. And even before those two things are done, there would have been assigned, and was in this case, a uniquely identifying case number that only applies to that particular decedent's case. So all information, findings of the autopsy, etc., would come under that particular case number.
And how are you made aware of the identity of the decedent?
As far as a case coming from the other county, that would have been made known to us upon the time of that death was reported to us.
Okay. So on the day in question, when you became involved, were you aware of the identity of the person from Carroll County?
Yes.
Okay. And that person, I believe you said, was Matthew Michael Mott, correct?
Yes.
Okay. And so when you have that information, when you do your job, do you do it in a methodical way?
Yes.
Okay. And is that a protocol that's done or a methodical way that's done in every case?
Yes.
Okay. And so what would the first thing you have done when you became involved with this case, with this decedent?
So after any initial examinations, as I said, by a forensic scientist, after we've taken our initial photograph that's following the person being received to our office, then I would, and after the x-ray is performed as it was done in this case, I would start my external examination, looking over the outer surface of the body to look for signs of pathology or disease changes or injury.
When you do an autopsy, do you do it alone or with someone else?
I have alongside me a pathologist assistant, and that person at my direction would assist in removing the organs from the body, starting with the initial, what's called the Y incision, which is the incision of the chest and abdomen. And I also have at my direction a forensic photographer that I would point out anything that I needed documented photographically, as I had in this case.
Okay. And so you indicated that you begin with an external examination, correct?
Yes.
Okay. And with regards to the decedent, Matthew Michael Mott, what, if anything, did your external examination reveal?
Yes. Mainly what I noticed is, aside from some other things like scars and tattoos, was that he had an injury on the left chest.
Okay, and when you see that, what do you do next, or what happens next in the course of your evaluation?
Starting with the initial part of the autopsy, the person is, and in this case I had him photographed as he appeared to me on the autopsy table, so before I would wipe any blood or do anything as far as cleaning. So I had as-is photographs taken. In this case, that's after he's received in the autopsy and he's on the table. And I also am making any notations of what I see. And then following that, and then of course I documented the injury as I saw it. And then following that, I clean the body and then take another series of photographs, as I did in this case. Again, head to toe, front and back, including the injury. I also, towards the beginning of the autopsy, I will collect things like hair. So I collected samples of hair and samples of blood as part of the initial internal examination. That's our DNA standard, and that's a routine thing that we collect, that we submit to the trace evidence department, that they will either keep or release depending if someone needs to collect it. So if someone's investigating the case, they may need to collect those items that we retained.
Did you do that in this case?
Yes.
Okay. And when you do an external examination, is it the entire body?
Yes.
Front and back?
Yes.
Top to bottom?
Yes.
Okay. And I know you have medical terms for those, but it's a complete external examination?
Yes.
Okay. And so did you notice any other injuries, scars, marks, tattoos as you completed the external examinations? And if so, where were they? And what did they look like?
Yes. I noted a number of tattoos, and I'm going after looking at the report that I produced in this autopsy. A number of tattoos on the left upper extremity. I don't know if you want me to read exactly what they are.
No, that's fine. You don't need to do that. Just a general of what you observed is fine.
And then, in this case, he didn't have any significant scars, but I would make a notation of that if he did. And then I went on to describe the injury, particularly the wound of the left chest. I did measurements of that wound. I also looked for any deposits around that wound, where what I would call the entrance wound. And then with the internal examination, after the incisions, I tracked the injury that wound was associated with. So internal injuries of the chest organs. And then I also tracked where the wound ended. And in this case, I saw 3 injuries on the left back. That represented the wound of exit that was connected to the wound of entrance of the left chest. And I also noted that internally there were injuries to organs and tissues, particularly the left lung, a large artery that's connected to the left lung. There was injury to a branch of the airway tube into the left lung, and there was also injury to the ribs overlying the left lung as well, in addition to injury to the rib area towards the left back.
When you noticed what you described as the wound on the upper, I believe you were pointing to your left chest?
Correct.
Okay. Do you measure that to document it specifically on the body?
Yes.
And how do you do that? What reference point do you start with?
First, I do a 2-dimensional measurement. In this case, I measured the wound as being 1/4 inch by 1/8 inch. And I look at its shape. In this case, I described it as to be ovoid. So as opposed to round, it was a little bit more ovoid. And then I I looked for any abrasion from around the edge of the wound. So I did see a margin of abrasion right around the edge of the wound, and I made a description of that. I looked, as I said before, I looked for any deposits around the skin surface immediately surrounding the wound, particularly the presence of what's called fouling or stippling, and I did not see any of that.
What's the purpose of looking for fouling and stippling?
The presence of the fouling and or stippling may give some information as to the proximity of the end of the barrel, in this case of a gun, to the skin surface, keeping in mind there may be intervening objects such as clothing or other objects that may prevent me from being able to see that, being that it was not deposited because of intervening objects. And then I went on to make a description of how high up from the heel the wound was, and then how far it was from the midline of the body. In this case, I described it as being 59 inches up from the heel, and then 3 inches to the left of the midline of the body.
And then you indicated you observed what you referred to as an exit wound. Is that correct?
Yes.
Okay, and that would be where on the body?
This was located on the left upper back.
Okay, and similar to the front, do you measure and do you document that?
Yes.
Okay, and what did you do in this case?
In this case, I noted that there were actually 3 irregular to rectangular wounds on the left upper back, and I measured each of those 1/4 inch by 1/4 inch, 1/4 inch by 1/8 inch, and then 1/4 inch by 1/4 inch. And they were directly over an area of fractured rib, which would be right under. And I made similar measurements, being 54 inches up from the left heel, and then 3 inches from the back midline of the body.
And then after that, did you notice anything else in the course of your exterior examination that was documented?
Yes.
Okay, what else?
I described the course and direction of the wound going through the body. So based on where it entered and then where the exit wound was, I was able to determine that the course and direction, in this case of the projectile traveling through that part of the body, was traveling from front to back, slightly to the right, or without any significant deviation, remembering there are 3 separate wounds of exit. And then going downwards. So basically where it exited was a little bit farther down than where it actually entered.
And how were you able to make that track? How do you do that?
So during the internal examination, I'm tracking the damage that the projectile did as it's going through the body. And so I mentioned there was injury to the lungs, there was injury to the ribs, there was injury to blood vessels and a branch of the windpipe. So I was able to track the damage that I could see and also the associated hemorrhaging or bleeding going through the body.
And so you do that on an internal examination as you do an internal examination.
Yes.
Is that in layman's terms?
Yes.
Okay, so at that point you'd already started your internal examination.
Yes, that's after the external examination, making notations, measurements, with the incision made by the pathologist assistant, and then with the internal examination of the internal organs, I was able to track the injury going through the body.
And is an internal examination conducted in a methodical process way as well as similar to the external examination?
Yes.
And how does it start, and how did you start in this case?
So the internal examination starts with what we call the Y incision. So it's actually an incision that's shaped like a Y over the chest and then down along the abdomen in order to be able to access the internal organs of the chest, mainly the heart and lungs, and then also to access the internal organs of the abdominal and pelvic cavities.
You talked about the trajectory that you tracked. Were there any other abnormalities or any other things that you observed in the course of the internal examination?
Yes. One thing in particular that I noted in relation to the injury was there was a large amount of blood that had accumulated on the left side of the chest cavity. So this is inside, surrounding the lung. And I measured that as being 2,000 milliliters, which is 2 liters of blood. As a result of the damage that was done to the lungs and the other structures, blood had accumulated inside of the left chest cavity.
And does that indicate to you anything?
Yes.
And what does it indicate?
That's a significant amount of blood that's lost from the circulation. The body's circulation is normally closed inside of the blood vessels. However, if there's damage, the blood can leak out of the circulation, and that has effects on the ability of the heart to function, the lungs to oxygenate the body, and the heart particularly to circulate oxygenated blood to the rest of the vital organs.
And you indicated there was about 2 liters or 2 liters of blood that you found, correct?
Yes.
And do you collect that and measure it?
Yes.
And how do you do that?
We have containers that have lines of measurement on them, so like small little bucket type containers that we fill with the fluid, and I can actually see where that line ends, exactly how much blood that was collected from the cavities.
And is there, do you know about how much blood there is in the average body or in a body similar to this?
In his body, he would have over 9 liters of blood based on his body weight and the calculation that I did in this case. Approximately over 9 liters, not 9,500, but a little bit over 9 liters of blood totally in the entire body for him.
And you found 2 liters in your examination?
Yes, in my examination.
Okay. Was there anything else in the course of your internal examination that you found that were abnormalities or things that were remarkable?
Yes.
Could you tell us what those are?
Yeah, he had a number of smaller superficial skin injuries, mainly on the head. He had a bruise or contusion that had a little bit of abrasion on the mid-forehead. He also had some abrasion on the right upper eyelid.
Hold on a second. Sorry for the interruption. You can continue.
Do you want to start again?
Oh, sure. As far as other minor injuries that I described, that was during my external examination. I described a small bruise on the mid-forehead, another small area of abrasion on the right upper eyelid. He had also two 1/4 inch in diameter bruises or contusions on the left knee, a 5-inch abrasion on the front of the left thigh, and also 3 small pinpoint type bruisings on the right knee and shin area. That was the extent of the other injury associated significant findings that I described.
And when you referenced the trajectory in your investigation and the path that you observed from the entrance room to the exit room, did you find any projectiles or anything during the course of your review?
No.
Okay. Does that happen in your line of work?
Yes.
Okay. So it's not an anomaly if a projectile is not there?
It is not an anomaly.
But projectiles could be there?
Yes.
As part of your evaluation, was there anything else in the course of your examination of the decedent at that time that you did that you found remarkable?
As part of the actual autopsy, I did note that he had some mild hardening of a large artery, the aorta. Again, mild. He also had some changes on the lining of his gallbladder, benign changes. And I also calculated the body mass index, which I normally do as far as the height and weight. So he was, based on the body mass index of 45.2, that's considered to be in the obese category. And we only describe this because sometimes it represents a risk factor for other things like hardening of the arteries or high cholesterol, among other things. So.
Was there anything else that you noted?
Not part of the autopsy. As part of the autopsy examination.
As part of your examination, do you take tissues or other samples?
Yes,
Did you take any tissues or other samples in this case?
yes.
What did you do?
I took representative portions of the major organs and had them stored in a fixative formalin type solution. That's just in case, for whatever reason, we needed to put samples in to look at under the microscope, which I did not need to do in this case, but we put portions to save for any eventuality that needs to be done. And the other part of the autopsy, what I did in this case was obtain bodily fluids, particularly blood and other bodily fluids like vitreous from the eyes, and I had those submitted to the toxicology laboratory.
And what's the vitreous of the eye?
That is a slightly thickened clear fluid that we can actually take from the eye and submit to the lab. If we were to have it tested, it would be for things like electrolytes, so we can know like if the person's dehydrated or if they have a kidney problem or if they have diabetes.
Were there any other fluids taken for now?
Yes.
And what were those?
A sample of femoral blood, which is from a vessel in the leg, one of the lower legs. Also, a sample of urine. I was able to get urine and submit that alongside the vitreous fluid.
What's the purpose of obtaining the femoral blood?
The femoral blood is one of the blood samples that are obtained. In this case, I also obtained heart blood. So there's two types of blood that is obtained during an autopsy. One is good for telling what's present, so that's the sample of heart blood that comes from the heart. And then the femoral blood that comes from one of the leg blood vessels is a preferred sample as far as if we want to make any interpretations of levels of medications and other substances. So that's why we collect those two types of blood.
And is that a standard practice in your field?
Yes.
And you also talked that you collected urine, is that correct?
Yes, urine, and then also was collected from the gallbladder bile. And I already mentioned vitreous humor from both of the eyes. Also, I was able to collect gastric material from the stomach and a sample of liver tissue and a sample of brain tissue. And these are normal tissues and fluids that we would collect and submit.
With regards to urine, what would urine help you understand, or what would you look for?
Urine is good for telling the pathologist if the person had recently used some type of a medication or substance. It may indicate that the blood also has that same substance circulating, but it might only be as useful of telling that the person used some type of medication or other substance in a recent period of time, so more like a historic use of something. The blood is better for knowing if the person used something more recently.
And is that also a standard practice to obtain that sample?
Yes.
Okay. And now, do you analyze that yourself?
No.
Okay. And who would analyze such a substance?
That would be a forensic toxicologist in charge of a staff of chemists and other toxicologists in a separate laboratory.
Okay. Are the results of those analysis and those fluids, are they reported back to you as the pathologist who conducted the autopsy?
Yes.
And why is that?
That's important because I need to be able to see if there are any other causes of death or contributing factors in the death, or maybe just so I know, if there's any degree of impairment or other issues that might be going on, whether that be related to medication use, other substance use, or some type of pathology, like, as I said, such as kidney problems or diabetes, that I may need to consider or factor in as a contributing part of the death, or maybe has nothing to do with the death.
And did you receive such analysis in this case?
Yes.
And what results did you find and rely on as you looked at the cause of death?
Yes, I received the report and I was able to see that the lab did detect a medication called sertraline along with its breakdown product. Sertraline, I believe the brand name is Zoloft. So it's a medication commonly prescribed for depression, but it may also be prescribed for other conditions not specifically related to depression. Also, there was detected the active byproduct of cannabis, commonly known as marijuana, and also another inactive byproduct or breakdown product of cannabis as well, alongside the levels that were reported. So that indicates to me there was recent usage of both the cannabis-containing product and also recent usage of a medication, the sertraline.
And are the levels reported to you as well?
Yes.
And were those levels within, for example, with a Zoloft, would they be within an amount, could you tell if they were within an amount prescribed?
I could tell by the level that it was not a toxic or lethal level, and it's consistent with what would be prescribed to someone.
Right, and with the product of marijuana or byproduct of marijuana, same question. Can you differentiate from the levels as to how much is there and what you would interpret it as?
My interpretation of the levels that were reported, particularly the active metabolite, the breakdown product, is that it's a low level, meaning that someone potentially had used it within the last few hours prior, in this case prior to his death, or within the last day or so prior to death.
Would either of those levels contribute to the cause of death?
No.
Okay. And as part of your duties, were you able to determine to a reasonable degree of medical certainty what the cause of death was?
Yes.
And would you tell us what that is and why you base your conclusion on that?
Yes. With the totality of all the findings, with a complete autopsy examination being performed, I was able to determine that the cause of death was as a result of the injury, specifically gunshot wound of chest with visceral, which refers to the organs, mainly the lung in this case, vascular, so any blood vessels, skeletal, ribs mainly in this case, and the surrounding soft tissues. So gunshot wound of chest with visceral, vascular, skeletal, and soft tissue injuries.
Another question.
Defense.
Dr. Matthew Mott weighed 297 pounds by the time you weighed him, right?
Yes.
Any active THC in his body?
He had reported an active breakdown product of THC, yes.
Just so the jury knows, there's a difference between the manner of death and cause of death, right?
Yes.
There's about 5 categories for manner of death.
Yes.
One of them is natural.
Yes.
That's self-explanatory. And the other one's accidental, right?
Yes.
Also self-explanatory, right?
Yes.
One of them's homicide,
Yes.
and that means death at the hands of another.
Yes.
And it's not, whether it's justified or not, it's just death at the hands of another.
Correct.
Not taking into account whether it's self-defense, justified, not justified.
Correct.
And one of them is suicidal, right?
Yes.
And that's death at the hand of yourself.
Yes.
And then the last one is undetermined.
Yes.
And then for cause of death, that's just kind of like the mechanism by which someone dies.
It includes in part the mechanism.
Okay. You said there was one entrance wound and multiple exit wounds.
Yes, a cluster of exit wounds, correct.
And that would be consistent with the frangible bullet being used?
Yes, I have seen that, correct.
And that's because the object of a frangible bullet is to disintegrate upon impact of a hard object.
Yes.
And you cannot determine whether or where anybody was positioned based on the entrance and the exit of bullets.
No.
But go back to the devil's lettuce. That's the critical question.
Thank you.
State of Ohio.
Briefly, the concepts of accidental death, suicide, homicide, are those in your field? Are those descriptor in your field? Are those descriptor words in your field? Or are they legal terms in your field?
They are classifications of death based on the circumstances surrounding the death.
Okay. And with regard to the exit wounds and the locations that you've testified to, for your investigation, is it necessary to know how far away somebody is or how close somebody is in relation to what you observed?
No.
Okay. And the, okay. I have no other question.
Fess.
No questions?
Okay, Dr. Armstrong, thank you. You can step down. Attorney Barnett, you have to call her. You are released. Thank you.
Thank you.
Okay. Prosecutor Barnett, I'm not going to hold you to this number, but how many more witnesses do you anticipate?
Can we approach you?
You may.
So yes, the devil's lettuce, hippie cabbage, the reefer madness. Once you start smoking it, you start putting on jazz records and it gets violent. So yeah, guys, I'm sorry. The internet kind of shit out on me and I didn't realize my mic was all jacked up since I started back up.
Okay, at this point, ladies and gentlemen of the jury, you are released to go into the jury room, to take a break, to get a drink, do whatever you need to do. Be close, though. I don't know. We're going to have you back in. I just don't know how long it's going to be. I'm not going to set a time on it this time. So get done everything you need to get done and then be ready to go.
Okay, so that was the medical examiner. If you guys weren't here at the beginning, she pointed out that in some states they're called coroners. In Ohio, out of the 88 counties, 86 of them are called coroners. A coroner is an elected position where you have to be a physician, and that's your only requirement. So there's a county I worked in as a prosecutor. The coroner was the local family doctor. So he got money and funding to install a freezer in his office. So if somebody died, they would freeze them and then send them out to Columbus to get an autopsy. It looks like
Okay,
here...
State of Ohio. So at this point, what is your intentions?
Here in the state of Ohio, we have no further witnesses. We would rest at this time. So
Ooh, Rule 29 motion. Rule 29.
submissions of state's exhibits that we introduced.
Okay, let's go over those exhibits because the numbers, you've skipped several numbers, so I want to be very clear, especially with the pictures because the pictures are not up here, but you do have the hard copies of those? Okay.
Gabby, they're not going to end for the day.
I'm
They're still
looking
an hour
at,
to go.
we admitted, well, you admitted one, which was a 911 call.
I'll bring it up in a
two,
second,
which was
guys.
the physical gun. 3, which was the Miranda waiver. 4, which was the sketch by the defendant. 6, which was a BCI scan, the actual software scan. I don't see a 5. Did you introduce a 5?
No, sir.
I don't see a 7 as well. Did you introduce a 7?
No, sir.
And then the next several, I'm going to say 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23 were all pictures.
Correct.
I don't have a 24. Was there a 24?
No, sir.
There's a 26, which was a picture. 27 was a picture. 28, 29, 30 were all pictures.
Correct.
Then the next
is
numerically
pretty
that I
normal for a
have is
trial to
42,
consolidate all the
which is a
exhibits.
picture as well, 43, 44.
Correct.
And then the next numerical is 51,
Correct.
which is another drawing by the defendant.
Correct.
54 was the cartridge,
Correct.
and 55 was also a cartridge.
Correct. I believe we labeled it a spent casing, but that's correct. The numbers
Right.
match, which you have, Judge.
Did I miss any exhibits?
No, sir.
Okay, defense, do you have any objection to any of those exhibits?
No, Judge, but we also moved to the defense exhibit A because it also came in during the state's procedure.
Very good.
No objection.
So no objection on the state's exhibits, no objection on the defense's exhibit A at this point. And so they will all be admitted, everything we just mentioned, and the state has officially rested at this point. Now, defense, it's 3:40, so do you need time to think about what you want to do?
Honestly, yes.
Okay, very good, that's understandable. So what we're going to do, yeah.
I don't want to, I do need to make a Rule 29 for motion for acquittal. We can do that tomorrow whenever we do that to make sure that you know I'm going.
I figured you would.
They're going to burn an hour of trial time?
We'll do that first thing in the morning, but prepare for your decision after that phase, what you want to do after that. Obviously, if you don't present evidence, then we're going to go straight into closing at that point. So, be ready either way. I guess both sides need to be ready either way for closing tomorrow morning after 29, depending on how the Rule 29 goes. Everybody in this room is aware of the weather coming tomorrow afternoon, so I have that in my mind as well. So I would love to get through the actual trial phase tomorrow and see where we're at, what time that is, and just go from there. But if we can get through the trial phase tomorrow, the evidence phase, we're going to be in a good position as far as the storm. So anything else from the state today?
I guess with regards to the exhibit involving the firearm, it is in the court's office. Would you prefer us to return it to evidence, or would you prefer to leave it locked?
It's locked up in there. I mean, yeah. And I guess for clarification, I'm not going to release both the rifle and the unspent bullet to the jury at the same time. If they want to examine them, I will let them see them, but I'm not going to have them in the room at the same time just for safety issues. So just so the attorneys know that in advance.
Fair enough.
And, yeah, okay. Anything else from the state then?
No, sir.
Anything from defense? All right, we'll bring the jury back in, but I almost imagine they're not ready. So we'll take a short break. When the jury's ready to go, we'll get them back in, and then we'll go from there.
Okie dokie. So what you just saw,
Let's make sure we got all our exhibits up here.
they were making sure all the exhibits were properly admitted and that both sides agreed on the prosecution's exhibits. As you guys heard in this case, there's only like 50 total from the prosecution. Unlike Theodore Edgecombe, where there were like 1 million. Unlike Kyle Rittenhouse, where there were 1 trillion exhibits. That's a pretty standard amount, and a lot of those were pictures. So there wasn't a ton of actual exhibits to go through. Now, if you noticed, some of them are numbers. Those are the prosecution exhibits. Some are letters. Those are defense exhibits. The defense, it sounds like they may actually not present a case. I don't know. But we'll talk about that in a second. They mentioned Rule 29, and so did I. The Rule 29 is a motion for an acquittal. Basically, the defense stands up and says the prosecutor has not proven each and every element beyond a reasonable doubt. Um, at that point, the prosecution gets to says, Your Honor, looking at the evidence in most favorable light, we believe we have, and reasonable jurors could make a conclusion that we have. Generally speaking, you don't win a Rule 29 motion, rarely, if ever, but you make it anyway because, you never know if you will win, and sometimes some courts have said it's been malpractice or ineffective assistance not to make that motion. So it sounds like they might make it tomorrow. It sounds like we're going to be done for the day on this case. Now, as far as whether or not they present any evidence, if the defense feels the prosecution hasn't met their burden, they may not introduce any evidence. They might just let it ride and call them out on it and see if the prosecution can win. That actually happens quite a bit. There's usually not a ton of evidence presented by a defendant in a trial. So this is a little more par for the course than Theodore Edgecombe. Leanne, they might have the mom call, or the mom, like who she called at first. They might have her. I don't know. It's up to them. I don't necessarily think they're going to have her testify since there's already video of her interview. Hey guys, I know you asked questions earlier. I missed some of it while the medical examiner was talking. Andrina, well, this morning, the detectives that were involved in assessing the crime scene and recapturing all the spent casings and taking pictures of everything testified. Then the kind of like the lead investigator testified. Then the medical examiner went, and that's it. So we're done at this point. I think somebody asked us earlier, I forget who it was, but they asked about is there, do attorneys and defense attorneys and prosecutors get paid the same? No. If you're a private attorney, you make whatever you make, and when you're a prosecutor, you make, the prosecuting attorney himself, the elected official, makes probably like about 115 grand a year, roughly. That's kind of like state mandated. They get paid that much, but his assistants might make like 50 or 60, sometimes more, but generally that much. Verna, no. Verna, the way the Rule 29 motion works is you tell the judge, we don't think they met their burden. And if the judge says no, then the trial continues. And at that point, the defense has the opportunity to present evidence. They may rest immediately, which is a very common thing, and that's usually how it goes. Then the judge will decide if there's still enough burden. If this prosecutor's met it, it immediately then goes to closing arguments and jury instructions. The burden of proof when it comes to self-defense is on the prosecution. They must disprove it beyond a reasonable doubt. And the rebutting of that is for the defendant to show by a preponderance. Think of preponderance of evidence like 51%. You just have to show it's, more likely than not. Beyond a reasonable doubt is way up there. That's like, when you try to quantify it, it's like 85% at least sure of something. I mean, the way in Ohio they talk about reasonable doubt, beyond reasonable doubt is when you would make the most important life decisions in your daily, like you're buying a car, you're buying a house, if you're going to send your mom or your grandma to go see a doctor who's going to operate on them, you're going to be goddamn sure that's about as good as you can choose. You've done your research and, you may have like second thoughts in your back of your mind, but you're as sure as you can be. And that's what beyond a reasonable doubt is. You're really damn sure this happened. You're damn sure they did this. You're not like, oh, kind of, maybe, sort of, I don't know. Gabby, I'm with you at this point. If it was just immediately give it to the jury, if I'm on the jury, I'm voting not guilty because they haven't proven it. That doesn't mean she didn't do this. I just don't think they've been able to prove it.
Okay, you can be seated. All right, we are back on the record on 21 CR 6643. At this time, ladies and gentlemen of the jury, we are done with today's hearing. We don't have any more witnesses to present today. We will be back tomorrow morning. I want to start, hopefully, I need you here by 8:15 tomorrow morning, and we're going to start as soon as we're ready. I do have another hearing in the morning that I have to take care of before ours, but we should be done with that hopefully by 8:15-ish. I am aware of the weather that's coming tomorrow, and so I'll keep that in mind as the day goes on, but we're in pretty good shape to be done with the evidence presentation phase tomorrow. And so we're on track for that. That's my hope, but that looks like that's what will happen. The evidence phase will wrap up tomorrow. And then from there, we'll see where we're at, and we'll look at the storm, and we'll see what's going to happen with that. And hopefully, you know, our weather people are pretty accurate this time, and we can make a pretty educated guess as to what we need to do to be safe. But with that, for today, you will be excused. Please remember all of the directions that I gave you at the beginning of the trial concerning looking up things about the case, looking at media, talking to friends and family, talking with each other about the case. And with that, though, we will see you in the morning. Be here by 8:15. So you are released for the day.
All right, guys. Now, this is why I want to tell you why I think they haven't gotten there yet.
Okay, absent that other hearing in the morning, I would have started us at 8 just because of the weather coming tomorrow. But we do have an 8 o'clock bond hearing that I expect will take 15 minutes or so. So be ready to go by 8:15. As soon as we're done with that bond hearing and everybody else is here and ready to go, we're gonna roll right in with this. So anything else from the state today? Anything from defense? All right, then we will adjourn for the day.
Yep, so it looks like we're done. Yeah, there's a big snowstorm coming to Northeast Ohio tomorrow, so I understand they're probably going to want to batten down the hatches. I'm going to have an early day in the office as well, but we'll see. Um,
So you're busting yourself right in. Oh my goodness. Oh geez, now you're in double trouble.
God, they got to kill that. That's driving me crazy. All right, guys, hang tight. I want to show you why I don't think it's self-defense, and I think there's a good reason why. All right, guys, when you look at this, this is a great. I use this in the future, and I've used this since I saw it when I was in law school. The burden of proof is very straightforward. When you look at it, look at the chart, and it should tell you, not proven guilty, unlikely, less than likely, probably, maybe, I don't know. None of that means guilty. Guilty means guilty beyond a reasonable doubt. Even if it's highly likely, that's not enough. It's that important. That is George Zimmerman's lawyer, Mark O'Meara. This is from, I think, 2013. So that's who that is. Now, Lori, I saw you you rolling your eyes about the Zimmerman thing, and I understand that, but what is there shows why you have to self-defense cases. You still have to go along with that burden of proof, and that once again follows down that road. Do I think she did it? Yeah, it sounds like she did, but once again, just because I think it's highly unlikely self-defense, that's not enough. They haven't gotten over the goal line, so I don't think they have a case. Now, as far as introducing like her history of abuse and things that may have gone on, it all depends on what that evidence is because there are preclusions to that. Um, there's only so much you can show in certain situations. So, without knowing the totality of all of her abuse, what it was at and who actually did it to her, I can't say for sure that that should be admitted. I mean, this guy may have done things that qualifies and could be allowed into court, but I have a feeling a lot of it might be prejudicial or irrelevant to establishing whether or not this is self-defense. But that's why, I'm not 100% sure it was self-defense. But they can't, they have to prove it. They have to stick the landing, and if they don't stick the landing, it doesn't matter how guilty you think the person is. If they can't deliver, then it's not guilty every day. Not with a case like this, I don't think so. She's testified through her interview. So her interview is the freshest thing. It's already happened. We know it. We have it. There's no point for her testifying again. Because that's out there. You can't cross-examine the videotape. She can't fuck up on video. She's already done. So I think that's the safest play at this point. Yeah, guys, hey, if you like what you see, I appreciate the like and a sub as well. Need to get to that 1,000 so I can start rolling around in my sponsor-provided Bentley. I'm just kidding. I won't forget there. So tomorrow there's going to be, I don't know if I said this earlier, there will be a massive snowstorm, and yeah, I understand why the judge wants to get that out of the way. If they rest their case tomorrow, they will immediately go into closing arguments and then jury instructions, and then the jury will deliberate. So we're actually 9K9s. I don't think we know. Because, yeah, if he's tuning her up in her bedroom, which he could have been doing, that's self-defense right then and there. But remember, like I said, it's self-defense kind of, it's like the tide. It goes in and out. You don't always have it. If somebody's hurting you, but then they stop and walk away from you, and they're clearly away from you, is it still self-defense? Not right that second. You have to show the immediacy that they could do it again right now. But if they're away from you, I don't know if they can. Matthew, that's what I would have done if I was worried about her testifying, was having her talk. More importantly, the detective was kind of cherry picking through what happened there, but also he was only being asked questions related to possibly incriminating things she said. So I think that was a way to get her testimony in, but also shows the prosecutor was kind of maybe hiding the ball a little bit. Brenda, he can do it tomorrow. It doesn't change whether or not they've met the burden of proof today or tomorrow. Um, Andrina, his hands might be weapons, but if he's at the end of the hallway, he can't hurt her with those weapons. He has to, she's going to have to shoot him to the point where he could come after him. That's the big thing. You have to show the immediacy, that it's an imminent threat. Not that it can be, because, yeah, it can be a threat, but is he going to do it, or very likely going to do it and able to do it right when you made that decision to pull the trigger? That's the issue of self-defense. You don't always have it. You have to meet the elements of self-defense every single time you use force. Exactly, Lori. Things could change in a second. Kind of like with Theodore. He punched him, and right then, his Jason could have fought back. But as soon as Theodore left, self-defense is done. It sounds like he put her head into the wall earlier before she shot him, but I mean that's part of the issue is it's not 100% clear. I mean, it sounds like he put her head into the wall, and then he made some. I have a feeling he was coming back for round two, and she center punched him. But who knows for sure. Yes, Andrea. Yeah, if the closer he is, the more likely it's self-defense. If some big guy's coming at you saying, "I'm going to kill you," after he's already beaten you, and you kill him, and he's within 2 feet of you, and he's walked that whole way down the hallway, yeah, you have a very good argument that he was coming to do something bad. If you shoot him from 20 feet away and he hasn't moved, that doesn't necessarily look as much like self-defense. Oh, I understand, but part of that is you have to show there's a threat. It's that immediacy. Like the way I try to explain it to people when it comes to self-defense is there's a couple factors, but there's ability, immediacy, and danger. Ability, can they actually do it? If a 90-year-old lady says, "I'm going to cut your fucking head off," she's probably not going to be able to do that. But a 20-year-old guy saying, "I'm going to cut your fucking head off," well, he could do it. But is he holding a machete or a knife or anything? No. Well, then he doesn't have the ability. But let's say he does have that machete in his hands. Okay. There's the immediacy. Can he actually do it right that second? Well, let's say he's standing outside your car window. Not necessarily immediate yet because you've got a barrier between you. Let's say he's standing outside your front door. Well, he's definitely not getting in. Let's assume your door's locked. Is there a barrier? Is there an obstruction? Is there something preventing him from doing it? And then there's danger. Like, are you actually in danger? That's kind of the would he do it? Would you have a problem? Well, him trying to cut your head off with a machete would be a danger, would be a threat. So you have to have all of that. And then there's also the idea you're the innocent party, you're not the aggressor. That one's kind of straightforward. In this case, it sounds like she, for the argument, she was innocent in the sense that she was not the aggressor, but I bet her and him were going at it when they were fighting. Yes, in horror movies, they always get in, yes. I mean, I'm a little torn between how imminent was the danger right that second. Um, that's the issue. Lori, what happens if he blocks her in? Well, she's not. I mean, he might be obstructing her trying to leave, but it wasn't as though she made her way down the hallway and he wouldn't get out of her way. She was standing at one end, he was at the other, and she shot him. So, if you're trying to leave, you have to show you're wanting to leave, and also, at that point, she could have called the police and he won't let me out. Uh, had he shoved her head into the wall after she was after she had he shoved her head into the wall after she was shot, there would be. Well, I mean, Leanne, maybe. I would just say it like this: people, when they get a hole, when people get holes poked in them, the body reacts in a multiple number of ways. Yeah, there might be so much blood it looks like he's at a splash pad and it's everywhere. Sometimes there's not a lot of blood. That's not indicative. Ace of Kings, no, not hitting harder on the bloodstream. I mean, think about it. If you smoke some dope or you have an edible, are you really aggressive? No, people on weed aren't aggressive. I really, you're the defense. You're trying to make the most out of what's there, but trying to tell people, even in a very conservative and rural area like Carroll County, the reefer madness happened, and one smoke of that demon lettuce, and he was dangerous. Uh, Nobody's gonna buy that. I mean, you have to be careful because if they think you're just bullshitting them straight out, the jury's not gonna like that. And I guarantee even the most conservative person in that county doesn't necessarily believe weed makes you dangerous. Well, it does make some bearing because it may impair his judgment. I mean, it does impair your judgment a little bit. It's not a ton, but you could show that there's something going on. Uh, Andrina, send me a link to that and I'll take a look at it. Yeah, irritability and mood swings can happen with Zoloft, but I mean, like all that's the bigger issue is like, is the guy bipolar? Is he schizophrenic? I mean, if he's having PTSD, is he having a full blown PTSD meltdown? Doesn't necessarily sound like it. It just sounds like he's a dick. Um, Also, it sounds like they both had mental health issues, and I'm sure many of you are aware from your world, your own personal experiences. People that have issues like that tend to find each other. There's that whole codependency issue. So, you know, this was kind of this was kind of bound to happen at some point, I think. Oh, I remember a question somebody asked when the medical examiner was talking about her education and experience. I think one of you mentioned that she was speaking about it so boringly. I mean, think about what you do for a job every day. Um, Somebody might be interested in it, and you'll just talk about it like, yeah, I do this, and yes, I do that, and blah, 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 blah. And to the person you're telling it to, it could be the most interesting thing in the world. Ace and Kings, when you're talking about parents and raising children and being on drugs, that's different. Yeah, if there's drugs in there, you can do some stuff, but I, that person being erratic was probably not just the weed, it was something else, either another drug or another mental issue. Um, I mean, Jody, yeah, but think about this. She just shot that rifle off. And in a confined space like that, here's what you hear. Eee. I mean, it's loud. It's gonna smell. She's probably like, "Oh my god, I just fucking shot him." There's probably a million things going on. So, but eventually she did call, and it sounds like she called fairly promptly. So, I don't think that's gonna hurt her too much. I mean, Leanne, yes, likely there'd be some sort of blood there, but I think that's you got to be careful because you never know for sure. Yes, I think all that happened before the shooting, though. Leon, I guess I'll say it like this. The two most dangerous words you can use are always and never. The judge is hot. Well, I don't know. Go slide in his DMs, Rita. Jody, I will not be able to cover this tomorrow. I've got court hearings and some stuff I got to go take care of, so I will not be around. Wow, these guys are fucking hardcore. They beat him to death with brass knuckles. God damn. Alright, we'll scroll up through this a little bit. Okay, so yeah, these stepbrothers beat their stepfather to death with brass knuckles for abusing their sister. Okay, well, there's kind of the issue. They beat him, but they took him to a field and left him to die. I mean, had you just beat the shit out of him and left him where you found him, that looks a less like it's a murder, and that looks a more like you beat a rapist trying to hurt someone. So let's see here. Oh, Weslaco, that's way down there in southern Texas, I think. Anyway, so a farmer found a dead guy in one of his fields. The investigators returned, and they identified him as their stepdad who had warrants out for continuous sexual abuse of a child and assault. Okay, well, not necessarily feeling bad for this guy. These guys have the same father but different mothers, and they're half siblings of the 9-year-old. So it sounds like the girl disclosed he had been assaulting her, but it wasn't like he was in the middle of going to assault her. Yeah, that's the issue here. Okay, yeah, so they found out, they confronted their stepdad, and they started beating on him, and he took off. They chased him down. And another guy who starts beating on him. They change okay, yeah, see, this is where it starts to look really bad. They start changing vehicles, and then they assault him for a third and final time. They place him in the truck and drive him off and dump him in an empty field. Yeah, they beat him in the skull with brass knuckles, causing severe head trauma, ultimately led to his death. He was still alive when he was left. Okay, so all three teams were arraigned. Melendez faces one count of capital murder. Jeez. To think about giving this guy capital murder for really this? Um, so, okay, and then, yeah, wow, okay. Welp, I mean, I don't know what to say there. Yeah, they're being charged with capital murder. That's not good. I mean, do I hope these guys won't ever face the needle for this, but, uh, it sounds like the big issue is, yeah, it was disclosed this guy's a pedophile and a sexual predator, but they didn't catch him in the act. If they caught him in the act, yeah, it's probably a bit overboard to kill someone, but honestly, nobody's really going to get mad if you kill some guy raping your kids. That shit happens. But a kid coming up to you saying, that guy raped me, then you chasing him down and then killing him, that's a little different. You don't get to do that. Rape is a violent felony. Most sexual assaults are violent felonies. You can use force to stop them from happening. But if it's already happened, you no longer have that force. So, like I said, guys, you don't get to, you know, you don't get to just kill people when they do illegal shit. I mean, do I really feel bad for these guys? Yeah. Do I think they should be on trial? No. But hey, the law's the law, man. You can't go run around doing that. More importantly, I have a concern with mob justice because think about the dumbest people you know. And then they think you did something. Do you want those morons chasing you down, trying to kill you? No, you don't want that. As much as we don't like the police for being kind of bumbling fuck ups at times, at least they have some standards we can rely on. Jody, I'm not surprised they're going to trial. They're probably going to take advantage of the defense of, yeah, we killed him and he was a huge piece of shit. So what? I mean, think about it. If you're on that jury, are you going to convict him? I mean, not only the fact you're in Texas, you could do that here in Ohio. I bet you can find people in almost every county in the state of Ohio who would probably say, I don't give a shit what they did, not guilty. I mean, I'm not going to lie. I'd probably sit there the whole time and say not guilty. So, I mean, that's not necessarily odd to go to trial. And also, they probably weren't given very good plea deals. The state does not like vigilante justice. They have a monopoly on violence. They don't like people being violent outside of their control. So let's say the plea offers go to 30 years in prison. I mean, fuck it, why not go to trial at that point? Oh, Verna, what about the guy from the school shooting and his parents being charged? His parents shouldn't be charged. Like, what did they do to make this happen? It's not like, it doesn't sound like they did anything to help him. I mean, that's part of when you're putting together some sort of conspiracy or plan. It sounds like the school is more liable than the parents are. They have this kid who they're terrified is going to be killing everybody and shooting the place up, and they don't search him. His backpack or him before he comes into the school. They just let him sit there. They don't have a cop nearby, like a school resource officer. It sounds like they knew about a ton of the problems and were just like, oh, we'll let mom and dad handle it. So I think there's a lot of passing the buck here. I mean, the kid, yeah, he's toast. I mean, he might try NGRI, not guilty by reason of insanity, but we'll talk about that. That's a hard standard to beat. And even if you do win and the court determines you're insane, you generally spend the equivalent amount of time in a mental institution, and that's not necessarily a better place than prison. In GPS, I don't think we know that the parents wouldn't take him out of the school. I mean, it's one thing if the parents don't think there's a problem, and the professionals, they didn't think it was too bad until finally the last minute. So, if the school's not kicking you out, I mean, you should probably still be there. The school did reach out, but the school wasn't saying your kid's a fucking time bomb. You need to get him out of here. We think he's gonna, start baptizing kids in the hallway. All they said was, we have concerns about him. But notice they only had those concerns and they weren't ready to kick him out. But if you think this kid's such a danger, why aren't you prepared for him to be a danger? I mean, if I think you're going to come kill me and shoot up my house and you knock on my front door, I'm going to search you. I'm not going to let you come into my house with a backpack and not check it. Like I said, I think the school is just as liable if the parents are. Oh, the school can say you're not allowed to be here. We're searching your backpack. I'm not sure what you meant, Ace. I mean, they can fully go in and say all that. If they have concerns it's an unsafe environment at home, they have most likely in Michigan, a duty to inform and a duty to report those things to Children's Services. So, I think they need to be careful about how much they try to crap on the parents here. The parents were more involved. How more involved were they? Did they tell him to go do this? Did they encourage him to do this? No. I mean, you have to show they were like an accomplice. Just being kind of lax and lazy. Did they break any laws that caused this to happen? But Ace and Kings, is it now the job of the parents to go narc on their kids and do all that? One. Number two, they are not trained professionals. And it sounds like his mom and stepdad may not be the most sophisticated people in the world, but if the professionals are there who have been trained and taught to know the warning signs, well, they apparently didn't think it was like the end of the world either until the very end. I mean, are you supposed to rely on the experts? If you are, then rely on them. And then when the experts screw up, the experts need to be held accountable, not the people following the experts' advice. They bought him a gun, but they didn't say, give it to him and throw it in his lunchbox and say, go make friends today, you little scamp. Like I said, him taking it, other than the fact that they bought a gun, there's no clear evidence they did anything illegal. Jody, just because the prosecutor said it doesn't mean it's true. I mean, I could say all kinds of shit and it's not true. Number one. Number two, I don't believe anything until I actually see it. The prosecutor can tell me what evidence they have, but until I've actually seen it, I don't care what they're telling me. They can say, well, we've looked at this and we have a report on it. That's great. I don't want the prosecutor to tell me what they have. Show me what you have. I don't need you to editorialize, not you, but the prosecutor. I don't need them editorializing something for me. I'm a big boy. I can read it. Let's see what they actually got. And I think that they're going to have a bombshell full of mouse farts at the end of the day. Sorry, I'm Jody. I misread it. I'm sorry. Yes, I think they're exaggerating, but that's the thing. An indictment can say whatever it wants. The prosecutor can say whatever they want, because nobody's contesting them. So, just always be careful about when you hear from the police. Yeah, Lori, but you know what? If I got in trouble, my dad would say he did nothing wrong. He was like looking at ammunition. There's nothing wrong with that. But you need the context. Did mom say, look, you're going to do stuff that's going to piss off the teachers. Learn not to get caught, getting everybody's cackles all riled up. That's fine. I would tell my kid the same thing. Hey, your teachers are a bunch of little ninnies who freak out at the word gun. Don't get caught looking at guns or, having a book with pictures of guns on you. Be smart about it. That's not really, learning to get caught for what? And if the school was that worried at that point, they didn't seem to kick him out. So, once again, it's learning to get caught about what? Granted, the trial's not over. The prosecution rested. So, we won't know till tomorrow if the trial's over. Exactly, Daniel. I don't think she meant if you're going to start smoke checking your fellow students in study hall, make sure you don't get caught. I think it was, I don't have time for these headaches, neither do you. Let's work on not getting caught. No, yes, okay, I agree. My dad would say, don't get caught killing people as well. Like, let's be real. I'm a defense attorney. Don't get caught killing people is really good advice. Because if you get caught, you're kind of fucked. Well, Ace and Kings, that should have happened at any school. Like I said, I think there was a failure of people in positions to do something about it. They didn't act. So now they're just pushing it off on mom and dad. The same thing in Ohio. There would have been people involved, probably getting the kid seen by a psychiatrist, but they didn't do it. Okay, so the verdict. Everybody right now, 61% not guilty. It's only 18 votes. It's not like with Theodore's where we had a couple hundred, but I'll take it. Yeah, I at this point, not guilty. It's not because she didn't do it. I just don't think they've proved it. Yeah, schools are overwhelmed and underpaid, but, all they got to do is make a phone call and it takes care of this kid. And they didn't do it. Andrina, yes, I actually did a video on Chad Reed getting shot. If you go back and look, it should be from the beginning of the year. Actually, like last year, actually. If you go back, but I did take a look at that. Yeah, yeah, and Andrina, I actually did it. Yeah, it's not a good one. It's bad. Do I think he'll get indicted? I think that's a coin flip at this point. Um, but it kind of goes back to, and you'll hear me say this in a bunch of these videos. If you want to get into fights with people over things, be real careful. And then also, if somebody's threatening you with a gun, saying "I dare you to shoot me" or "You don't have the balls," that's really not the smartest idea in the world. Facey McGee, I'm not sure, but I hope they do. And if mom and dad are going to face criminal charges, people in the school need to face criminal charges. Well, Andrina, it's not even especially nowadays. I mean, you just never heard about this stuff before. Um, before the internet really took off, people would give two shits about what happened in Hee Hawville, Texas, or nobody would care about what happened in Carrollton, Ohio. I mean, Carrollton, Ohio's population is like, hold on, let me actually check. Okay, I mean, think about this. Carrollton, Ohio, where this is taking place, that's the county courthouse's location. It's generally like kind of the biggest town in the county and also the most central town in the county. There are 3,300 people in that town. That's it. I mean, think about this. You guys live all over. Andrea, I think you live in Puerto Rico. How likely would you have heard of some domestic violence shooting that happened in BFE, Ohio before the internet? You wouldn't have. So, I mean, it's just more of you hear about it more, you see it more. That doesn't necessarily mean there's more of it. It's just we're learning about more of it. Well, have a nice day, Facey. Well, guys, I mean, that's it for today. I mean, if anybody's got any other questions, I'll stick around for a couple more minutes. But if you know nobody has a question in the next couple minute or two, I'm probably gonna hang it up for the day. Like I said, I won't be at this tomorrow, so I'll probably have to do a recap. Oh, you're off the mainland. Okay. Yeah, see, Lori, I mean, I never heard of the Pinellas High School shooting, and I don't think anybody except people that were there would know about it. Daniel Mothersole, that is a very astute point that I don't think the Oakland County prosecutor is willing to admit that, Oakland County borders on Detroit, and yeah, a lot of things happen. But yes, you'd have to be prosecuting parents of gang related activity, which would not be some lily white people in the suburbs. So I think there's some other considerations they didn't fully sort out before they did this. Yeah, guys, so that's it today. Remember, like, share, subscribe, and I will see you guys coming around. I do have something coming out on Thursday set up, and then I probably get this knocked out tonight. So, anyways, you guys have a nice night. You guys take care.